the High Court convicted and sentenced Sedina Tamakloe in absentia. In July 2024, the government of Ghana submitted an extradition request to the United States for his surrender to Ghana to serve a sentence. After over 2 years of court proceedings, the United States authorities notified the government of a surrender in January this year. She arrived in Accra on Tuesday, June 9, 2026. Officials of the Ghana Police Service and the Ghana Prison Service have taken her into custody and are making the necessary preparations for her to begin her sentence. Meanwhile, the Attorney General is scheduled to make his counterparts at the United States Department of Justice for bilateral discussions on all pending extradition requests between the two countries. If you do it for Ghana, they'll send it. So now we are saying that if we send them, send our S2.
Exchange rate.
Which one is the exchange rate? Well, we've been joined on the line by lawyer David Ametepe, also because this is a story published by Ghana Web that puts everything into context. And it says, former Chief Executive Officer of the Microfinance and Small Loan Center, Sedina Tamakloe, has filed an appeal at the Court of Appeal seeking to overturn her 2024 conviction and sentence by the Accra High Court. In a written submission filed on February 10, 2026, and cited by Ghana Web, Tamakloe's legal team argued that the charges used to prosecute her were defective and failed to provide sufficient details about the offenses she was accused of committing. The appeal challenges her conviction on multiple charges, including conspiracy to steal, stealing, conspiracy to cause financial loss to the state, causing financial loss to the state, causing loss to public property, improper payment of public funds, unauthorized commitment resulting in financial obligation to the government, money laundering, and the breach of the Public Procurement Act. This is a quote from an appeal. This is an appeal against the judgment of the High Court delivered on 16th April 2024 and convicting and sentencing the appellant of the offenses of, and then they list the offenses. According to the defense, several counts on the charge sheet merely repeated the wording of the law without clearly stating the specific acts of omissions that form the basis of the allegations. The lawyers argued that this violated Article 19.2 of the 1992 Constitution, which guarantees an accused person the right to be informed in detail of the nature of the offense being charged. The appeal further cited previous decision of the Supreme Court and Court of Appeal, which the defense said established the defective particulars of offenses could render a conviction unsafe. Lawyer, thank you very much for your time and a good morning to you.
Good morning, sir. And good morning.
And from the sound I hear, you are on the road. Well, let's first start with, because we are all wondering, okay, so we wanted her extradited to Ghana. She is now in town. What happens following her return to Ghana? Do you send her before the High Court? What happens? Or what is the process that is usually followed?
Wow. I've just listened to what you write with respect to some pending appeal and all that. But that is news to me. I'm not aware. But it is expected. Well, the government of Ghana took all reasonable steps to procure extradition and then eventual arrival in town. And I believe that all necessary procedures and requirements under U.S. law were satisfied, hence the extradition. I also cited some short release by the U.S. Embassy in Accra confirming the extradition and the arrival at the request of the government of Ghana. Now, Madam Sedina Tamakloe is in Ghana, and the government of Ghana and the relevant authorities are now firmly in control. She is no longer outside the jurisdiction where we need anybody's blessing to take any steps. So you ask me, what happened? Of course, she had a conviction and a sentence to serve. And as we are all reading in the news that upon her arrival, she was whisked away quickly by the relevant authorities. Of course, at this stage, the court has finished its work. Having rendered a sentence, the court has no business. The High Court, has no business now. The rest are all administrative. Administrative in the sense that she is now in the hands of the executive arm of government, starting from the court registry, where the judgment will be certified and the relevant warrant, such as the remand warrant and other relevant papers that will move from the court to the prison authorities, and the director of prison acting on this will carry out the necessary orders made in the judgment. And that is to say that she will have to serve the appropriate sentence, barring any other intervention.
So that is to say that the processes that would have been undertaken after the judgment was delivered are now going to happen.
Yes, of course. But then, given the fact that she was sentenced or tried and sentenced and convicted in absentia, and that she didn't appear in court or was not in court on the day of his conviction and sentence, he may have to appear before a judge.
May
be the case that he may have to appear before a judge to have his very orders repeated to her.
You said may.
He may, because some are of the view that the judge has become what we call a fan-tooth official. In other words, the judge has no business in the matter again unless any post-judgment action, having to do with the judgment. So in that case, one will argue that the judge has no business. The rest is administrative. The necessary remand warrant, certified judgment, and all the processes that will accompany her to the director of prison to effect the orders of the court will not require the intervention of the judge in that regard. Others are also saying that because she wasn't present in court when the conviction and sentence were rendered, then she might be brought before the court and be made aware of what transpired with respect to the judgment. Now, that said, now hearing from you that there is, in fact, an appeal, I'm not surprised.
And I'll come there. I'll come to the appeal and how it changes things. But I'm also wondering, the judgment was delivered last year.
Yes.
When do we start counting from? Let's assume she's serving the sentence and without appealing. Do we start counting from last year, or you start counting when she's officially behind in prisons?
Was it last year or 2024?
Yes. 2024. So that's even last 2 years.
2 years, yes.
Yes.
Interesting, because ordinarily the judgment takes effect from the date it's rendered or delivered. Okay? So if she were to be around and taken to prison immediately, then of course she will be deemed to have started serving her sentence immediately the judgment or after the judgment was rendered, and time will be reckoned as such. Now that she's going to commence prison term from now, almost 2 years after the conviction. It is a matter for the experts, especially the prison authorities, to determine how time will be reckoned. I'm not sure of this. I hear people say that the time will be reckoned from the day he actually starts her prison term. Otherwise, the one will be suggesting that, assuming that her extradition and arrival takes place 10 years after the conviction, then she will have no prison term to serve. She will be deemed to have served her sentence fully. That although may be a matter that will make sense, a position that I don't think makes sense. So let the prison authorities tell us how they reckon time in this kind of situation.
Okay, so it means that you have no precedent to refer to
Honestly,
go back to.
I'm not sure about this. I must confess. I can still find out how such situations are dealt with, but I've given what do you call it, the position that if time will be reckoned from the date of judgment, in which case the commencement of the actual commencement of the prison term will be reckoned from the date of the judgment, regardless of when the person actually starts serving the sentence. Then a situation may arise where, when a person comes to start the prison term at a future date by which time the prison term would have been deemed to have totally elapsed, that itself will render the judgment completely ineffectual and won't make sense.
I see. Now, what effect will the appeal she has filed have on these processes as outlined?
Of course, something that, because she obviously never contested the case, having waived her right to defend the action and took shelter elsewhere, she will be deemed to have no case to canvass on appeal, but that would be quite too simplistic a position to take. Regardless of the fact that she may have been tried and convicted and sentenced in absentia, she is still entitled to her right of appeal. So once an appeal has been properly so lodged, and in criminal appeals, there is no time limitation, although the 1 month period within which appeals have to be filed from the date of the judgment. Appeals are ordinarily allowed when time is extended at any time after the appeal, after the date of the judgment. So I believe that the appeal has been properly lodged, even if it is improperly lodged because it was filed out of time. An application for extension of time will always be granted to file an appeal at any time. Now, with the appeal pending, I don't know what stage it is at the moment. Then at the moment, we only have the notice of appeal, which has been properly filed. The options available to the lawyers could be to either apply for a stay of execution of the judgment or an application for bail for her pending appeal. These two options are available.
Interesting. And I'll start from where you landed. Stay of execution, application for bail. This is somebody that the state has to look for and find and bring her down to come and serve a sentence.
Yes.
Would that help any case, in any case for bail? Because I realize that you always see the person is a flight risk.
Well, such are the positions to be canvassed by both sides. In the case of the state, which I'm not, that is the Republic, represented by the Attorney General and his able state attorneys. Of course, they will make a case that she is not entitled because in both cases, whether an application for a stay of execution pending appeal or a bill pending appeal, these are within the absolute discretion of the judge hearing such applications, whether before the trial court or the appellate court, because they are entitled to file either applications before the court that convicted her at the first instance, if only the record of appeal has not yet been transmitted to the appellate court, then the trial court will hear these applications, whether for bail, pending appeal, or for stay of execution, pending appeal. And her lawyers will be entitled, assuming that such applications are refused at the trial court, to repeat these applications before the appellate court. Whichever way, they must make a strong case. Case of she being a flight risk, well, will feature prominently, but her lawyers will also make a case and give the circumstances of her being tried in absentia and must be able to convince a judge hearing such applications.
Quite interesting. But then I go back to what you said earlier. You are saying even the appeal itself, not the part about perhaps being filed out of time, which may also be one of the things that you suspect the state can raise, but the issue of also you not being tried in absentia, or are you suggesting that also creates a header for her, that the state can go to court and argue that she's not entitled to an appeal?
As for appeal, she's entitled. She's the only time that a convicted person is not entitled to an appeal is when the person pleads unequivocally guilty and is convicted on his or her plea. Okay? But even in those circumstances, appeal may lie. For instance, not against the conviction, but the sentence. But assuming that even in those circumstances, it is detected that the very charges forming the basis of even the plea were improperly laid or breached certain fundamental principles of law or the substantive law giving rise to the charge in the first place, an appeal may be considered. So the fact that she was tried in absentia doesn't deny her the right to appeal. And that's the first thing. And I will be surprised how the state will raise such an argument against an appeal simpliciter.
Interesting. Let me conclude and so that I let you go. I know work starts soon. There is the issue then of, if you read Felix Kwachiofosu's write-up, he's also talking about the Attorney General meeting her counterparts at the State Department to talk about the other extradition requests that have been made to the U.S. This was filed somewhere back in 2024. We have only concluded in June. Does that tell us? Because this yesterday I was also reading a newspaper story where questions were being raised about even the MP that's currently being the Ghanaian MP that's currently being held in The Hague hasn't even been transferred to the US yet. What should we be learning about the time frame within which you can realistically get some results on this kind of extraditions and some conclusions? Should we be thinking about the fact that the MP's one will take 2 years? Ken Foyata will also take 2 years, if it is not already 2 years, among others. What should we be learning about the time frame for achieving this, even though even in this case, there was a judgment of the court?
I think each case must be examined on its peculiar facts and circumstances. And so the time frame will not apply across the board. However, if there is anything to learn, as you put it, we need to understand that once your citizen or national is found in another country, then your jurisdiction does not extend to that host state. I mean, the requesting state jurisdiction ends within its territorial bound, and therefore you can only make a request to the host state where the fugitive is hiding. And any extradition process is governed strictly by law of the host state. In Ghana, we have our Extradition Act, the Act 22, and these laws exist in almost every country. And in the case of U.S., the U.S. law determines the procedures and the requirements which must be met. In the case of Hague, as you mentioned, in respect of the MP, it's not a simple request that you make and say, look, surrender this person to us, and it is done. No, you have to go and make a request. The request is first made administratively, but it may take a judicial process, ending up before a judge or a court or a tribunal for that matter to determine the propriety of the request. And these matters take long because the fundamental right of the individual to a fair trial or to be treated fairly are all considered. All extradition laws take into account our obligations under international law. Remember that a person suspected to have committed a crime or who has even been found guilty after proper trial before a court of competent jurisdiction still has certain rights that cannot be denied. If you look at our Act 22, for instance, a Ghanaian court or a Ghanaian political authority may refuse to extradite a foreign national hiding in Ghana if it is found out that the alleged offense for which a person is being requested to be tried or having been convicted is not an offense properly recognized by the laws of Ghana or is of a political nature, purely a political, a victim of political, execution rather than a proper and well-founded crime. So if you read the U.S. release from the embassy with respect to Madam Atedo, the U.S. authorities say they were convinced that she had been found guilty of an offense after a proper trial within a court of competent jurisdiction in Ghana. That offense for which she was tried and convicted, the U.S. authorities said that it was one recognized by them. If the authorities were not convinced, this request would have been declined.
Well, lawyer, thank you.
You're welcome, Sena. Have a nice day.
You too. Always educative speaking to lawyer David Ametepe. And what we're discussing is the arrival of Sedina Tamakloe in town. The U.S. authorities, she's been extradition process that started somewhere in 2024 has been successful. And so she arrived in town yesterday. We also understand that her lawyers have in February this year, filed an appeal against the sentencing and, of course, the decision of the court. So what would that mean to what everybody expects will happen? But there's somebody who said she was brought in silently without anybody finding out. Sneaked in. Well, we are continuing that discussion, and I hope David Ametepe's intervention puts a lot of things in proper context for you. What is supposed to happen, what might happen, and what to expect from the other cases, because